All right. Well, welcome to today's webinar entitled Practicing Fiduciary Duty. It's not just about the money. My name is Corey Martin. I'm with the Iowa Hospital Association. Just a couple of notes before we get started. We will have time for attendee questions after our presenter remarks. Please use the chat tool to type in your questions. I'll also be sending out a recording of this webinar along with the presentation handouts in the next couple of days. If you have any technical difficulties, please type that in the chat feature or call me at 515-822-4967. It's now my great pleasure to welcome today's presenter, Michael Wyland. Michael is the author of more than 400 articles on nonprofit governance, operation and accountability for the Nonprofit Quarterly, a print magazine and online news service specializing in nonprofit organizations. Michael has more than 30 years experience in technical assistance, education, and consultation with nonprofits. His experience has been quoted in more than 100 publications, including the Wall Street Journal, the Chronicle of Philanthropy, and the USA Today. As a partner in Sumption and Wyland, he specializes in governance, evaluation, and effectiveness with nonprofits and government-affiliated nonprofits. Please welcome Michael.
Thank you, Corey, and thank you everyone for coming this afternoon. Really appreciate this time together. I'm going to move real fast through some slides that I could spend a lot more time on than I will, but as Corey said, you'll get copies of everything as we go along. And there will be plenty of opportunity for questions. This is just a slide telling you a little bit about what Corey just said. I've been a consultant to nonprofits, but I've also been an executive director for nonprofits, and I've been a board member of nonprofit organizations. So I've seen the nonprofit boardroom from 3 different angles. What we're going to cover today are first some operating assumptions, then we're going to talk about fiduciary duty, and finally we're going to get into risks and accountabilities. And spend a little bit of time on something many nonprofit executives and board members, trustees are unaware of, which is that the IRS actually has rules for conflicts of interest and excessive compensation and so forth, and they're referred to collectively as Section 4958, also known as intermediate sanctions. Finally, we'll talk a little bit about a few of my recommendations for process and actions to help your organization stay ethical and stay legal in the area of fiduciary duty and conflicts of interest. Now for the assumptions. First operating assumption is that most people are honest. Most people want to do the right things for the right reasons. You know, this is not a matter of my coming in or anybody coming in and saying, we assume you're going to break the law, so we're going to have to tell you how not to. Most people want to do the right things for the right reasons. However, on the other hand, speed limits are sometimes referred to as benchmarks of opportunity or kind of guidelines. We can fudge a little bit. You know, if speed limit's 55, we might do 58 or 60 and just assume that that state trooper isn't going to pull us over on the interstate. So, you know, we are willing, generally speaking, to take a little bit of liberty with the established rules. Most people are unaware of the specific ethical and legal considerations surrounding nonprofit board service. A lot of people think that because their hearts are pure and they're trying to do the right thing, that anything they do in serving that mission must by definition be correct. And so they get surprised when they find out that no, there's actually a body of law and ethical guidelines and local ordinance and practices, policies, procedures that address how a nonprofit and how a nonprofit board of directors does its work. And some folks will even take offense when introduced to these considerations. It's like, how dare you assume I would ever do anything illegal, immoral, or fattening, you know, while I'm a board member, because, you know, my heart is pure. And as I said, I'm trying to do all the right things. Well, there are some things that appear right from the outside that the nonprofit world and the regulators have said, well, you got to slow down a little bit. Operating assumption is that when we're talking about nonprofits here, we're talking primarily of nonprofit organizations is defined in IRS Section 501c3. What most people think of as nonprofits, what most people think of as charities or public charities. For those of you who work in district hospitals or county hospitals where there's a governmental element of oversight or ownership, many of these rules that apply to nonprofits are very similar to those that apply to government. Plus, of course, the requirement in government that is not in the nonprofit sector for public access to meetings and even public input at meetings. And what constitutes a public meeting. A lot of times if you have a quorum, that constitutes a public meeting. That's not a problem in the nonprofit world, but what I'm going to talk about primarily are nonprofits. But I fully acknowledge that there are governmental hospitals as well as mixed entity hospitals, where the rules may differ a little bit. And the other operating assumptions I'll bring up is that a conflict of interest can either be permissible or impermissible. There are some people who say that conflicts of interest are by definition wrong, and that's not quite true. You can actually manage conflicts of interest using documentation and disclosure in such a way as to mitigate the potential damage that a conflict of interest might present to the organization and or its leaders. So conflict of interest is not something that is in and of itself illegal or unethical. It's more a matter of how you manage it and whether it can be managed in an effective way, that really determines whether something is okay or not okay as a conflict. Now, fiduciary duty. There are a lot of times when you hear that term and you assume it has something to do with accounting or finance, and the CPA is talking about it, and everybody else in the boardroom kind of, their eyes glaze over and they say, oh, that's about the money stuff. And if I know how to read a balance sheet and a financial statement, then I might understand fiduciary duty. Otherwise, I zone out. And actually, fiduciary duty is something far simpler. The Legal Information Institute at Cornell Law School uses this definition of fiduciary duty, and I modified it just slightly for one of my e-newsletters that I did about 6 weeks ago. I just said fiduciary duty simply means taking care of something that belongs to somebody else and putting their interests ahead of your own. And that's really what it comes down to, is if you're a leader of a nonprofit organization, fiduciary duty simply means that the interests of the organization trump any personal interest or outside interest that might be set in comparison or competition with the interest of the organization. It's your role as an organizational leader to put the interest of the organization ahead of others' interests. And the something can be tangible or intangible, but regardless, a fiduciary, such as a nonprofit board member or a senior manager, takes care of it. It's really about that trusteeship. It's really about taking care of something that belongs to somebody else and treating it in the most respectful and helpful way possible. And fiduciary duty has to do with assets and tangible assets. We all know, what they are. Here are several examples on the left-hand column. But on the right-hand column, I want to introduce you to some other assets that a lot of organizations and a lot of individuals don't think about, as being elements of fiduciary duty. Human capital, your staff, your volunteers, your stakeholders, intellectual property. Hospitals, like any nonprofit organization, has intellectual property that's very valuable. Everything from their logo to to the materials they develop, marketing materials, philanthropic materials, all kinds of intellectual property that they own as an organization, and as an act of the leadership of the organization to protect those assets. The third one is the most intriguing. It's brand and reputation. Among the assets that a fiduciary has to conserve and protect is the brand of the hospital. What is its reputation in the community? What is the promise that that hospital and the logo and the people and the uniform and the building, what promise does that make to the stakeholders in the community? That is part of fiduciary duty, because I can guarantee you that if those elements are harmed in some way, that will migrate to the bottom line. It will migrate to problems with employee retention and employee attraction and turnover and all kinds of things that have a direct financial impact on your hospital. And there can be other intangible assets as well. And, you know, and I'm sure you can probably think of some yourselves that I have neglected to put on the slide. Fiduciary duty traditionally comes down into three simple subgroups: the duty of care, the duty of loyalty, and the duty of obedience. The duty of care basically means taking your role as a fiduciary seriously, actively participate in the organizational planning and decision making, and making sound and informed judgments. You know, it means showing up at the meeting ready to work, you know, having reviewed the board packet. It also means that the CEO or her representative should prepare board packets that are complete yet easily understandable by board members who may or may not be healthcare professionals. They have to value your time at the same time that you as a trustee should be investing your time in your service to the hospital. And the goal of that, of course, is to be an informed board member and to actively participate in the deliberations and the leadership and the governance of the organization. The duty of loyalty, you know, we talked a little bit about that. Put the interests of the nonprofit or the organization before any personal or professional concerns. You know, if you're wondering which hat you're wearing in the boardroom, figuratively speaking, whether you're a car dealer or a general contractor or you're a physician, if you're wondering whether you're representing your business or your practice or representing the interests of the hospital, there's an inherent conflict going on, whether it's acknowledged or not. And while you are acting as a board member of the hospital, then the interests of the hospital have to take first place. And as I say, to avoid potential conflicts of interest where you can and manage the unavoidable ones. And finally, the duty of obedience. You make sure the organization complies with all applicable federal, state, and local laws and regulations, and that it remains committed to its established mission. It's amazing how often the mission, vision, values, and strategic priorities, sometimes goals, of the organization get put aside and, you know, brought back out maybe once a year, but they really don't influence the routine decision making of the organization. What you really need to do as part of fiduciary duties is to every so often go back to those touchstones and say, why are we here? What is our purpose? Who do we serve? And as we're deciding about whether or not to build a building or whether or not to expand a practice or whether or not to shut down a clinic, you know, we have to be able to say, you know, what is our mission? What are our goals? And is the work that we're doing right now relevant to those goals and relevant to that mission and honoring the goals and honoring the mission? If not, then maybe you need to change the mission or change the goals. But that's part of fiduciary duty. Now, risks and accountabilities. Accountabilities really begin with yourself and colleagues. It's highly unlikely that if you're working on as a senior executive of a nonprofit hospital, that the FBI or the IRS is going to bust down your door, or that the Attorney General is going to start issuing subpoenas and saying, we think you're doing something wrong. We need you to you know, tell us everything you're doing, and we may just take you to court and make you straighten up your act. That happens, you know, in hospital environments more likely than not through Stark law or federal anti-kickback issues. But as far as governance is concerned, the most risky thing, or the biggest risk you have, is really the risk of disclosure, the risk of exposure. The board has done something wrong. The board chair has done something wrong. You know, a subset of the board has taken a decision that is contrary to the interests of the rest of the board and not disclosed that, et cetera. You know, there are a lot of ways this can present itself. Well, what triggers exposure? Well, it could be as simple as a disgruntled employee or a disaffected patient or client. Maybe they call the local newspaper or TV station and say, I'm upset and I want to tell you my story. And sometimes that story ends up in the paper or ends up on TV, and all of a sudden you have to respond to that. And once it ends up on TV, once it ends up in the paper, there may be some political interest. And even if it's not in the paper or on TV, if that disgruntled employee or patient or client contacts their local representative or contacts the governor's office or the attorney general's office, that by itself could trigger an inquiry, if not an investigation. But such things can be either instigated or exacerbated by poor communication by hospital leaders and representatives. And we're not talking about developing a crisis communication plan here, but I highly advise you to have a crisis communication plan. And I have an example for you of what can go wrong. Happened in Minnesota about 20 years ago. I'm aging myself because I remember when this happened. There was a news allegation that Allina Health had used Minnesota Medicaid revenue to pay for lavish board retreats. It made great copy to talk about fresh flowers in the board members' hotel rooms every morning, and board members receiving chair massages, during the board retreat. And Allina felt required to make some kind of a statement. And the Allina spokesperson responds, "Oh no, we don't use Medicaid funds for that. We use donor funds for board retreats." Well, all of a sudden, Medicaid kind of, backed away and say, okay, that's not really our thing. But the Attorney General got very interested in her role as the guardian of philanthropic activity in the state of Minnesota. And she took point and really saw an opportunity to bring Allina to heel on how it used its donor dollars in governing its organization. And of course, a lot of this, again, played out in the media, causing reputational harm to Allina Health, particularly in the Minneapolis media market. Well, let's talk a little bit about conflicts of interest and related issues. Conflicts can be financial. Obviously, if I'm being paid by somebody else, that's going to influence how I act. Loyalty to other entities. I had one example of this in my practice where I was working with, of all things, an animal shelter, and one of their board members was the founder of a competing nonprofit animal shelter, but still maintained board privileges at the original shelter. And so, he was in the board meetings literally taking notes at shelter A so he could run over to shelter B that he founded and tell them what the competition was doing. There was no money involved, for him, but it was definitely a conflict because of loyalty to other entities. And you can have conflicting roles and conflicting relationships that lead to conflict of interest. One example of this from a number of years ago was Mount Sinai in New York City. They have an interrelated hospital, medical school, and real estate holding company, all of them 501c3s. Most of the board members were members of were board members of two or all three of those 501c3 corporations. And in a transaction that involved two of the three entities or all three entities, there were a lot of people in that boardroom who didn't know whose interests they were supposed to be representing. If there was going to be land that was going to be sold by the medical school and purchased by somebody else, whether it's the hospital or somebody else, people in the boardroom didn't know whether they were representing the hospital, the real estate holding company, the medical school. And these were some very intelligent people. Henry Kravitz, well-known venture capitalist and corporate raider, was on the board of Mount Sinai at that time. And it was kind of a frightening thing to hear that, executives of Fortune 100 companies and venture capital people, routinely, carrying billions of dollars, in their portfolios, were confused when they were sitting around a nonprofit board table. So those conflicting roles and conflicting relationships can definitely lead to conflicts. Talking briefly about the law, and I'll come back and talk about intermediate sanctions in more detail in a couple of minutes, but there is a federal law that addresses conflicts of interest, excessive compensation, and what's called private inurement. And private inurement is simply a situation where in a transaction with a nonprofit, the other entity gets more benefit than the nonprofit does. You know, if I buy $100 worth of office supplies for $100, that's fine. But if I, as a nonprofit, buy $100 worth of office supplies and I only take delivery on $10, well, then that office supply vendor, you know, committed an act that resulted in private inurement to that vendor. And of course, the nonprofit managers and board could potentially be on the hook for that same transaction to whatever extent they were involved in approving it. The IRS is serious enough about nonprofits having a conflict of interest policy that they actually include one in the application materials for tax exemption. You know, that's what Form 1023 is. If you want to be a charitable entity, a 501c3, you fill out Form 1023. Well, Appendix A of the instructions is a sample conflict of interest policy. And oh, by the way, it's specifically written for nonprofit entities that are going to be hospitals. If you're a non-hospital, then you edit out the parts that pertain to hospitals. But it really is an interest on the part of the IRS. And I've also included in the slide a reference to the training materials that the IRS uses to train its field agents and external CPAs on the issues of intermediate sanctions, of conflict of interest at the federal level. The states also address nonprofit organization governance and conflicts of interest. I've included links to what is done in the state of Iowa, the state of Minnesota, and in the state of Wisconsin. If you're from another state, I can almost certainly guarantee you that your state will also have similar laws in their or statutes in their corporation statutes. I can also almost guarantee you that no two states' statutes read exactly the same. They're often similar, but they're seldom exactly the same. So whichever state your hospital is incorporated in, or is registered as a foreign agent or foreign entity doing business in another state, then you're subject to that state's corporation laws. You know, have your general counsel take a look at them and make sure that your organization is in compliance. But in addition to law, there's also the issue of ethics. And two ethical guidance areas, one from the American Bar Association for attorneys who are members, and one from the American Institute of Certified Public Accountants for members of the AICPA. And what they basically say is that if you're on a nonprofit board, you should not also have a financial relationship or even a professional relationship without financial compensation with that nonprofit. So, you know, you can provide all the legal information you want as an attorney serving on a board, but if you're providing legal advice, if you're acting as their counsel, either with or without pay, the American Bar Association considers that to be a conflict of interest and advises its members to not do that. And similarly, the AICPA advises accountants not to provide accounting services for nonprofits on whose boards they serve. And in both cases, they even go so far as to address individuals who are in partnership, should the partnership or the corporation that that member belongs to be involved. And the general advice is no. So if you have, you know, so there are some ethical considerations depending upon what profession you're talking about. I went out looking for professional guidance or ethical guidance from healthcare associations and societies and found nothing. I even reached out to experts at the American Hospital Association, at a couple, or excuse me, American Medical Association, and a couple of state medical associations, And I also reached out to the American Society of Association Executives, asking for any guidance from any healthcare organization about ethics for their members of serving on nonprofit boards. And there wasn't anything out there. However, the federal government hasn't left this field bare. You still have the ever-present Stark Law, which I note is formally titled the Ethics in Patient Referrals Act. So we do have a reference to ethics, even though we're talking about a federal statute. And of course, there's also the False Claims Act and the federal anti-kickback statute. If you're a doctor or physician or surgeon or other healthcare professional serving on a nonprofit board, and you are subject to the IRS requirements of intermediate sanctions and how to conduct yourselves in terms of conflicts of interest and reasonable compensation and so forth, that magnifies the impact of these other federal laws on you as individuals. And again, I'm not trying to give you legal advice. I'm simply saying that you should talk to your counsel, whether you're a personal attorney or talk to the corporation counsel for your hospital, and make sure that what you do and the way you do it, is legal and ethical. Now, intermediate sanctions, as we've talked about, the penalties introduced under 4958, they were put in place about 20 years ago, even though most people have never heard of them. They've been in the IRS code for almost 20 years, 19 years now. They're an alternative to the revocation of an organization's tax-exempt recognition. Because what happened in the past was, if something was going wrong with a nonprofit, there really was no way to punish the individuals who were in charge. The only option the IRS had was to revoke the tax exemption. And if they revoked the tax exemption, then the organization couldn't operate as a nonprofit anymore. And that would harm the community. It would harm the beneficiaries, the clients, the patients. And it would not necessarily harm the people in charge who put the organization in jeopardy. So the IRS came up with intermediate sanctions. These are all the people who are covered. Now, what I want to say is that basically, if you're an organizational leader, or if you're a family member, and that's the important part here, their family members, then you are subject to special scrutiny by the IRS as regards intermediate sanctions when you are a member of a nonprofit board, or if you're a senior manager of a nonprofit organization. And the other thing to remember, besides the fact it's not just you, it's your family members, is there's a 5-year look back period. So even your former trustees or board members, your former CEO is still subject to scrutiny as a disqualified person, just as your current CEO and current trustees are subject to scrutiny as disqualified persons. So, whoops. Okay, and I apologize for that. Come on, there we go. The other thing to talk about is that conflicts of interest often involve money, but they don't have to. Conflicts exist and need to be managed even when no money is exchanged. And I'm going to make a parenthetical comment about money. Money is not about the cost of something. Money is about the fair market value of something. So it doesn't matter what the nonprofit paid or didn't pay to get something. It's what the donor or the manager or the board member or whoever gets in terms of fair market value. So it's about fair market value. It's not about cost, and it doesn't even have to be about money. Example is there was a private museum in New York City where the board chair offered her nephew, a new architect, to design a new building at no cost to the nonprofit. Said, great guy, great young man, starting out his practice, and this would be a great way for him to contribute. And and I as board chair will make that available to the organization at no cost. So all of a sudden, well, who can beat free, right? Well, the U.S. Tax Court disagreed. They found that the opportunity for the nephew to add to his portfolio of work was something of value, and that the opportunity was denied to others by not doing an open competition or bid process. So even though it was free, it still constituted an impermissible conflict of interest because that board chair exerted her influence and the board went along with it to bring in her nephew without looking at the market to see who else was available and willing to provide the service and who was the best qualified, best situated to provide the architectural services for that new private museum building. That's just one example of how it doesn't have to be about money. Now, if you are a board member or a senior manager of a nonprofit organization, there are a couple of really important things to know. Buried in section 4958, there are a couple of key phrases. The first one is the rebuttable presumption of reasonableness. In other words, the IRS is instructed and courts are instructed to say that we have to presume that everything's being done the right way for the right reasons. We have to prove that something's being done inappropriately or illegally. That just because it looks funny doesn't mean that it is. That we actually have to be able to substantiate that something wrong happened and that individuals in charge of the organization allowed it, enabled it, or actively encouraged it to happen. The second protection or consideration is what's called safe harbor. In other words, if a nonprofit organization goes to the trouble of having written policies and following them, that's the important thing, is you can't just have them, you have to follow them. If they document their actions and if they rely on independent experts for issues like compensation, having documented the fact that you've put a major contract out for bid, and you have copies of those bids and you have copies of how you distributed the announcement. Those are all safe harbor. Those are ways of demonstrating to the IRS and incidentally to the public or the media or the politicians or the regulators, whoever, we're trying to do things the right way and here's how. Now, the catch-all phrase the IRS uses is the last one here, called facts and circumstances. In other words, it depends. Every time you try to nail down what works and what doesn't work, the IRS is likely to come back and say, well, it depends on the facts and circumstances. And so it gives them the freedom to actually investigate and make a determination based on their interpretation of the statutes and the regulations. Now, for excessive compensation, some of the things you can do, there should be a compensation setting process for the CEO, and I believe also for the CFO, but definitely for the CEO, that is board-led. The board has to be in the lead of setting compensation for the CEO. The CEO should never be coming to the board and saying, I did a salary survey and this is what the survey says I should be paid. No. The board should lead the compensation setting process. Third-party salary surveys are great as a safe harbor, testing the market. And you can look at other nonprofit organizations. You can even look at for-profit organizations that do the same thing in the same area with roughly the same revenue and the same number of employees and serving the same number of patients, et cetera. You can come up with comparable examples, both from the for-profit and nonprofit world. That's acceptable under intermediate sanctions. And the other thing about compensation is to implement the compensation setting as part of the regular CEO assessment and contract negotiations process. And let's assume that everyone here is part of a hospital that has a regular CEO assessment process and has a contract with their CEO That's very important. If it's not being done, it should be done for the protection of the hospital and for the protection of the CEO, both. Recommended processes and actions, private inurement, secure at least 5 publicly solicited written bids for major projects. There's an exception. If you're a very small nonprofit organization, you can get away with soliciting only 3 bids. Now, this is my personal opinion, and I'm not an attorney. I advise attorneys and advise board members and advise CEOs, but I'm not an attorney. My reading of the federal regulations is that this requirement for multiple bids for an open process includes the CEO's employment agreement. When the CEO goes through succession and a new CEO is hired, it should always be as the result of a arm's length search process. Now, you can still hire the internal candidate if there is one, but that internal candidate has to compete against external candidates in order to be successful. An example of private inurement that I like to cite is one from California, where a board member donated land to a nonprofit on condition that the land not be sold or improved for an extended period of time. So they gave the asset, but they did not give the the opportunity to sell the asset or do anything else with it. 3 years later, that same board member wanted the nonprofit to sell the land to his grandchildren at a price significantly below market. I gave you land worth $5 million. 3 years later, I've come back to you and I want you to sell it to my kids for $2 million. Well, no, you can't do that. Somebody might try to make the argument that doing something is better than nothing. That $2 million is better than zero. But no, that nonprofit had land worth $5 million. It really needed to get $5 million for it, if not more. It needed to have an appraisal and to have the land sold at market. Managing conflicts. Develop, implement, and review conflict of interest policy regularly. There's a sample policy, like I said, available from the IRS. And every board member should review the policy and sign the annual conflict of interest disclosure. That's a 2-part process that you really have to have people read the conflict of interest policy so they know what it says, and then on a regular basis have them update the disclosure of what conflicts they may have and attest to the fact that those are the conflicts and that there are no others. Excuse me. And what I maintain is that you should assess the conflicts as part of the board recruiting process. As Peter Drucker likes to say, begin with the end in mind. If the end is to have a board that is as free as possible of conflicts of interest, and where you can't avoid them, you document them and manage them, then you really begin that with the board recruiting process. That should be part of the screening that happens before someone gets on your board. You should implement an expectation of disclosure, and that should be for current board members and senior managers. It should also be for prospective board members. Our culture is that we run our hospital in this way. And of course, you document all conflict of interest determinations and processes. That's part of your safe harbor, is having good documentation. And if it might be a conflict, it almost certainly is. If you're not sure, it probably is. It's probably worth digging down and exploring. And as I said, culture is as important as rules. You can have the rules and kind of ignore them or pay attention to them when you want to, but the culture that you need to encourage on your board is one of saying that we want to be ethical, we want to be legal, we want to minimize conflicts, we want to adhere to fiduciary duty and take our role seriously and work in the interest of the organization and the community. And when all else fails, ask yourself what your mother would say if she heard a story about something going on in your hospital boardroom or at your hospital. if it's something that she wouldn't understand or wouldn't necessarily approve of, if she read it in the newspaper or online, then odds are you need to check your facts. Not only because you want to make sure you're doing the right thing, but also, quite frankly, you want to make sure to be able to explain it. I had a friend of mine who served on a hospital board who said that his role was asking tough questions of the other board members and of the senior leadership of the hospital, because, as he said, if they can't answer my questions inside the boardroom, there's no way they can answer the same questions outside the boardroom. I'm the first test. I'm the first opportunity they have to check what they're doing, how they're doing it, and how they're communicating it. And yes, sometimes they hate me for it, but most of them understand why I'm doing it. If your mother or grandmother, is reading this and saying, gee, this doesn't sound right, then you probably need to be looking at it in more detail. Well, that's really what I have, and I'd like to open it up to questions. Corey, do we have any questions so far?
At this time, we don't, but if you do have any questions, please go ahead and put them into the chat box and we will get through them.
Right. This is, there's so much here that a board or a CEO or a CFO needs to take account of, and a lot of it are things that are outside the normal agenda of a board meeting. And so I apologize if I've overwhelmed you, but I think there are a number of issues that may come up in board service that touch on fiduciary duty and touch on conflicts of interest and compensation issues, not just for hospitals, but for all nonprofits. And by the way, one thing that I did not mention, because it's rather technical, but I'll say it now, is that intermediate sanctions, that IRS Section 4958, that applies to 501c3 public charities, including churches, even if they've never applied for tax exemption. It applies to churches and mosques and other religious congregations, as well as to public charities that have applied for tax exemption. It also applies to 501c4 organizations. The social welfare groups are also subject to intermediate sanctions. If you're a 501c3 private foundation, there is a different section of the Internal Revenue Code where conflict of interest rules apply. It's Section 4941. But intermediate sanctions is for public charities, for religious congregations, and for social welfare organizations, the 501c4s.
All right, well, not seeing any questions. I want to thank you, Michael, for your presentation.
Sure.
Oh, here you go. One question that just came up.
Oh, okay.
My organization is a public county hospital and our board is elected. This has caused a lot of problems in the last few years.
I could see where that might be an issue, because I can see several things. An elected board doesn't necessarily result in members who are committed to the mission of the organization and committed to seeing themselves as a member of the board, acting collegially as a group to benefit the community. And sometimes when people are elected, they believe their constituency is the people who elected them. And that gets to be an issue, because there is a conflict there between loyalty to those who elected you and loyalty to the organization on whose board you serve. And that can present some very thorny situations and even dilemmas. Some members are not committed. There are clear conflicts of interest, yes. And unless there are qualifications for election that go beyond the I'm a resident of the community and I'm registered to vote and I've lived in the town or lived in the county for longer than X number of months or longer than a year, that's typically what a political candidate has to do. if that's all it takes, then yeah, you could have the car dealer, you could have the general contractor, you could have the office supply business owner, any number of people there on the board who have a personal financial interest in the decisions made by the hospital and by its leadership. And that can be very difficult to navigate. And we have had clients in the past who've been in that situation, and we've attempted to work with them. The good news is that most of the time, once this discussion is held about fiduciary duty and what conflicts of interest are, many of the people involved will actually make a good faith effort to work towards serving in the role for the right reasons. It's very seldom that you end up with someone who's such a curmudgeon or gadfly that they refuse to accept the fact that there's another way of operating. Is there a fiduciary duty regarding hospital quality and patient safety beyond finance and reputation? That's a really good question. And, I'm tempted to say something off the top of my head, but I really shouldn't, because in my work, I really try not to get into issues of quality and patient safety, except to acknowledge that they're very important. They do exist. And all hospitals and their boards and medical committees need to be, intensely aware of that at all times. But I have not seen any particular statute or federal regulation that compels, fiduciary duty beyond that. But what I would say is that fiduciary duty includes everything that happens in the organization. Here's a distasteful example of that I'm a little bit aware of is when Jerry Sandusky about 10 years ago, was arrested and prosecuted. His charity, the Second Mile, had an affirmative responsibility to identify that activity that he did with clients, with the young boys that organization served. And they didn't do that. And that was a failure on their part. And it led in part, that in part led to the state of Pennsylvania compelling the Second Mile to disband. So there is a fiduciary duty to take care of the organization, including how it does its programs and services. And is there an entity that can help us? I would begin with, the counsel for your hospital. And one thing I would encourage you to do is to have legal counsel for your hospital that is specifically well-versed in nonprofit, or as they call it, exempt organizations law, if you're a nonprofit hospital. Having an attorney who's well-versed in healthcare law is very important. There are a lot of hospitals that have counsel, and they use them primarily for business contracts and employment issues. But healthcare law and exempt organizations law, nonprofit law, are specialties. And most attorneys are not well versed in those areas because most attorneys are not called upon to practice. But I'd begin there, but I would also rely on your state hospital association and your American Hospital Association to see what resources are available there to assist you. And you're right, conflict of interest is difficult to prove. The good news about conflict of interest is that an apparent conflict of interest is often sufficient to spark a discussion about whether an actual conflict exists. One example of a conflict that I didn't mention in the main presentation was at Jerry Sandusky's charity, the Second Mile, they had not one but two board members who each had one of their employees also on the board. And what that meant was that subordinate employee who reported to their manager, who was also on the board of the Second Mile, it meant that those employees were inherently conflicted. It's like, I don't want to vote against my boss sitting in the nonprofit boardroom. So there are examples of conflict, that don't involve money, but they could involve a relationship between two individuals or more outside the boardroom. There are a lot of ways to slice and dice the conflict issue, but if it's an apparent conflict, it's worth taking a look at. I should mention also that my wife and business partner, Margaret Sumption, comes from a town of 250 people in north central South Dakota. It's almost impossible to not have a conflict of interest in any organization in that town, simply because the leadership cohort of that town is so small that, you know, the chamber chair may also be on the school board, may also be part of the Economic Development Authority, may also be part of you know, the parade committee. And again, that's an issue where the conflicts need to be identified, documented, and managed, you know, as a way of saying, hey, you know, we've done the best we can. And, you know, the fact we only have 250 people living in the whole town gives you an idea of the pool we have to draw from. You know, conflicts happen, and they happen in small towns and they happen in big cities. And it's more a matter of how you document them and how you manage them, you know, than merely saying, okay, well, you know, I can't do that, or you can't do that. But the apparent conflict is enough to have the conversation. And of course, those individual board members are honor bound to disclose their conflicts on a regular basis. And not just once a year, but between meetings and at meetings. If something comes up that they have a conflict on, they should be telling the rest of the board about it and offering to recuse themselves, offering to, you know, not only not vote, but also to leave the room while it's being discussed, and to not have discussions outside the boardroom with anyone, and not have access to the documents that are informing the board's decision on that issue. You know, it's a breach of honor on the individual's part before it even becomes a problem for the board as a whole. And the fact that the individual chose not to disclose could be part of the safe harbor for the board and the organization. So, but it gets back to, you know, bringing people on the board whenever possible who understand what conflicts of interest are and are willing to disclose and willing to manage them. I know that doesn't provide all the comfort that I would like to give you, but I hope it's at least a start as the way to think about this and talk about it. And I want to make the offer right now that I'm willing to speak by Zoom or by telephone with anyone attending this webinar, you know, about issues in your particular organization, understanding that those issues can sometimes be sensitive. And that's just my open invitation to you, that I'll be willing and, you know, quite welcoming to address any questions or any concerns that you have, you know, about your organizations or about anything I've said during this webinar, because I'd be very interested to learn from you. So when you get the slides, my contact information will be on the slides. Also, if you search for my name or my firm's name on the internet, you'll find it pretty quickly, I assure you.
All right. Well, Michael, thank you very much. And with that, we will adjourn for the day. Be on the lookout for an email from me that will give you the recording as well as the slide deck. And you can email Michael or even myself, and I will get questions to Michael, and we can help you with any questions that you have. We want to thank you for participating in this and look forward to seeing you in our next events. And have a great afternoon, everyone.
Thank you.